from the Chartered Accountants Australia and New Zealand via video conference, the Institute of Public Accounts, the Financial Planning Association via video conference, the CPA via video conference, and I thank you all for giving us your time today. I trust that parliamentary privilege information has been provided to you, and there's additional material available if you require it. We have here submissions number 5, number 9, number 11 and number 37. If there are any additions or corrections to those submissions, does anyone would like to make any changes? All good? Okay. For the Hansard record, could I ask each of you please to state your name and the capacity in which you appear here today? Start.
If I may take this one.
Yeah, that'd be really helpful. One, you can breathe, and two, we can hear you.
Thank you, Chair. My name is Vicky Stiliano, and I'm from the Institute of Public Accountants.
Right. Who'd like to go next? Ms. McWilliams? Can you hear me?
My name's Cam McWilliams, and I'm the Business Reform Leader at Chartered Accountants Australia and New Zealand.
Who's next?
My name's Benjamin Martian. I'm the Head of Policy at the Financial Planning Association of Australia.
And my name is Ketty Waller. I'm Head of Public Practice in SME at CPA Australia.
Thank you. Would each or any of you like to make an opening statement?
Thank you, Chair. I will start and then pass on to my colleagues. Thank you for the invitation to present to the committee today. Firstly, I would like to acknowledge the traditional custodians of the lands of Australia and their continued connection with the land, waterways and communities, and pay our respects to their elders, past, present and emerging. Chartered Accountants Australia New Zealand, CPA Australia, Financial Planning Association of Australia, Institute of Public Accountants together represent over 350,000 finance professionals in Australia, New Zealand and around the world. Through our combined membership, we represent over 80% of financial planners who have actively been involved in the regime for over 10 years. We welcome moves to strengthen regulations that fight money laundering and terrorism financing. Money laundering and terrorism financing are illegal practices that severely damage our financial system. We support the global initiatives to combat this activity and recognise the importance of Australia meeting its obligations as a member of the Financial Action Task Force. As professional associations for accountants and financial planners, we are committed to acting in the public interest and contributing to a robust system that prevents criminals from using Australia for illegal activities. Our members work across a wide range of sectors, including in practice, from large firms to sole practitioners, large financial services providers to self-licensed advice businesses. In business, from major multinationals to SMEs, the public sector, not-for-profits and academia. We hold our members to high professional and ethical standards, including the requirement to undertake a degree of customer due diligence, meet record-keeping requirements, and to undertake screening for and to be aware of suspicious behaviour by new and existing clients. Lastly, I refer to the IPA's office in the UK, which is an authorised supervisor for AML purposes and supervises approximately 2,000 member firms. We know from their experience that a proportionate, risk-based approach is essential, and that an overly complex system, such as in the UK, has resulted in significant compliance costs in order to meet the AML CTF obligations. I now hand over to Ketty Waller from CPA Australia.
Thank you.
Thank you, Vicky. In our submissions, we have aimed to assist with shaping the future design and implementation of the expansion of the regime to include the accounting profession, balancing regulation with risk, and strengthening our members' contribution to detecting and reporting potential money laundering and terrorism financing. We note the importance of undertaking an analysis of the AML CTF risks compared to the cost of compliance for businesses that would be captured, including, if applicable, any industry contribution levy. It is important to be cognizant that money laundering and terrorism financing risk is proportionate to the size of a business, the number, nature and location of clients, and the value of transactions, so policy responses should be pragmatic. For example, we are supportive of imposing the obligation to undertake customer due diligence, or CDD obligations, on all providers of accounting services. Such an obligation should not only reduce the risk of money laundering and terrorism financing, but it is also good practice for firms to verify their customers' identity. However, the ATO and the Tax Practitioners Board recently released client verification guidelines that align with the AML CTF CDD requirements, meaning that tax practitioners are now performing these checks. Furthermore, professional accountants have additional obligations under their Code of Ethics that requires that they must respond when they become aware of non-compliance or suspected non-compliance with laws and regulations. This includes money laundering, terrorism financing, and proceeds of crime. It is therefore evident that some of the AML CTF requirements and obligations significantly overlap with or emulate existing professional requirements imposed on the members of the accounting profession by their respective professional bodies. Importantly, these obligations only apply to qualified accountants, as opposed to those that may call themselves an accountant, but who are not members of a professional accounting body. I would now like to hand to Karen McWilliams, Chartered Accountants Australia and New Zealand.
Thank you, Kelly. In developing our responses to the committee, we engage with our respective memberships within Australia and overseas, particularly in New Zealand, where our members are already subject to requirements under New Zealand's AML CFT legislation. From their experience, there are some critical factors that we consider will assist with achieving the greatest benefit from Tranche 2. Firstly, that an assessment be undertaken on which existing mechanisms have led to the successful identification of money laundering and terrorism financing activity. Such an assessment should then be used as a basis to determine any future requirements and obligations for accountants. Secondly, as Vicky and Keddy have highlighted, our members are already subject to a wide range of existing professional and ethical standards. The inclusion of accountants should take into consideration existing regulatory obligations and industry oversight that could be effectively leveraged. The duplication of existing compliance obligations on accountants would exacerbate any compliance burden and associated cost, particularly for our small practice members. And an unintended consequence could be higher costs to small businesses and consumers for accounting services, as small practices seek to pass on their increased cost. Further, small practices may cease to offer designated services if compliance obligations are excessive, which may in turn inadvertently displace the risk of money laundering and terrorism financing to service providers that are not members of a professional body or outside the regime. We recommend a cost-benefit analysis of the regulatory options for accountants is undertaken, including, if applicable, any industry contribution levy. Thirdly, there should be extensive consultation with a broad range of stakeholders throughout the process, including raising awareness with consumers. This will contribute towards a more effective and efficient regime and establish a collaborative approach to increasing the resilience of Australia's financial system to criminal threats. Critically, the design must recognise accountants are inherently different from financial institutions and will require specific amendments to the regime rather than simply being captured under the current regime. I'd now like to hand over to Ben, representing the Financial Planning Association.
Thank you, Karen. From the perspective of Financial Planning Association members, financial planners have been subject to Part B programs for over 10 years and have been an outsourced professional for the Part A programs of financial service product issuers. Our members have benefited greatly from the willingness of product issuers to develop and adopt an industry standard ID verification form through collaboration between the Financial Services Council and the FPA. Unfortunately, not all issuers have adopted the industry standards, superannuation funds in particular. And despite the government adding financial planners to the statutory declarations approved witness list, not all issuers will accept financial planners ID verifying their clients, despite the professional relationship they have with their clients. An emerging issue we would like to see supported by the government and AUSTRAC is a technology-first ID verification process used by Part A entities to support the Know Your Client obligations. Despite significant advances in ID verification services over the past 10 years, virtually no product providers will accept a technology-enabled ID verification service and would prefer to still receive a certified photocopy and a wet signature on a form. While this is generally frustrating, the current pandemic has shown the issues with this approach when trying to support Australian consumers manage their financial affairs. In conclusion, while Australia has a comprehensive and tough money laundering and proceeds of crime laws in place, further efforts to prevent financial crime are a good thing. As professional bodies, we stand ready to assist with this challenge, and we welcome the chance to discuss our submissions and these issues with you here today. Thank you.
So, Senator Scarr, are you right to head off for the committee?
Yes, I am, Chair. Thank you all for attending today. And I note, I think you're the first witnesses we've had during the course of the day who are representing people who form Tranche 2 who will actually be impacted by the rolling out of the Tranche 2 reform. So I think your evidence is going to be important, as has been all the evidence we've heard during the course of today. The first question I've got is, as part of rolling out the reform to Tranche...
Paul, we can't hear you. We've lost you. You can't see us either.
As part of that process, prior to rolling it out to...
Senator Scarr, we've lost your audio for a while. Could you just repeat your question?
Yeah, sure. Well, I paid you all a number of compliments first, so just take that as noted.
We'll take the compliments as read. Yeah.
As read. The main point I was asking is, does there need to be a simplification, a modernisation of the Know Your Customer due diligence requirements under the legislation prior to rolling it out to Tranche 2? That's the first question. The second question is, as part of that modernisation process, does consideration need to be given to the specific circumstances of each of the body of professionals that you represent to make it fit for purpose for each profession, if you like? If I could go to the Chartered Accountants first.
Thank you, Senator. I think I'll probably best to respond to, I guess, the second part of your question around really, does it require a tailored response? And I think, as I indicated, sort of accountants will need to have a sort of tailored, I guess, response to this. They're not the same as financial institutions, and their interaction with their clients are different. They are also already subject to a wide range of obligations under existing both ethical and professional standards, but also, as I think Keddy indicated, already under the ATO as tax practitioners. So I think all of those things need to be taken into account. But I suspect Ben is probably best placed to specifically comment on, I guess, the Know Your Client CDD and how that actually should be perhaps modernised before rolling out.
Yep.
Thanks, Karen. As I noted in the opening, financial planners have been subject to Tranche 2 obligations, Part B obligations under the AML-CTF Act, and have been doing the Know Your Client requirement on behalf of product issuers for over 10 years. I'll probably take a slightly contradictory view here to my colleagues in that financial planners are under so much regulatory change at the moment, and the Know Your Client obligations and the providing ID verification and the forms we've developed with the Financial Services Council are fairly well embedded. They have been for 10 years, and any changes to the process or the obligations around that are just another change and another cost that financial planners are going to have to bear. So from that perspective, the FPA is quite comfortable with the item 54 reporting obligations that financial planning licensees have, and we wouldn't really want to see a change in the Know Your Client obligations at this point. But I guess the main point would be, when you have a professional relationship with a client, it's quite easy to know who your client is from a financial planning perspective, because you're generally dealing with an individual. It's much more complicated, I think, in accounting, because you have a lot of different business structures and trust structures and organizational structures, and knowing your client and providing the right kinds of documentation in that framework is a lot more challenging than what it is for financial planners.
Okay. The Institute of Public Accountants.
Yes, thank you, Senator. I might just add to what my colleagues have said that I think it's important to also look at the client and document verification requirements that are flowing through the ATO and the Tax Practitioners Board at the moment. We're looking at having a consistent standard and having a look at developing minimum standards. And I think in time we'll see how the implementation goes, what needs to be changed, and to see how it can be tweaked. I might also add that there's also a lot of other regulatory reforms that are flowing through. There's the director ID requirements, there's the modernising business registers changes that are taking place. So I think it's also important and useful to have a look at the cumulative effects of these and other regulatory reforms, and to see how they're implemented and how practically they're going to sort of work in the future.
So is it fair to say we shouldn't be looking just at what's under the AML legislation, but we also need to consider the professional standards, the ethical requirements of those who are members of your relevant organisations, also what's happening in the taxation space in terms of director identification? We need to consider all of that globally, and then once we've done that, come up with, as user-friendly, the most efficient and effective process which is suitable for each profession. Is that a fair comment?
Yes, I would agree with that, Senator. I think it's critical to take a holistic approach rather than just focusing on the AML requirements, which obviously are critical and are core to this. However, it's not just the FATF recommendations and requirements and the AML legislation. It's so many other things that are happening across the board, and including technological advances, which are going to be a big part of compliance with all of these requirements. So, and as my colleagues have said, the accounting professional and ethical standards are also a critical part of this. There's a whole regime that surrounds those. So I think, yes, it is critical to take all of these things into consideration and the overall impact on reducing ML and TF.
Okay. We did receive some evidence today in relation, I guess, firstly with respect to the modernisation of processes and the use of technology, which is bringing down compliance costs, which is quite favourable to all the participants in this process. There was some evidence provided with respect to cost of compliance. I'm just interested in terms of what the latest information is coming out of jurisdictions like the United Kingdom and New Zealand with respect to cost of compliance, especially for smaller service providers. Australia is a country with vast areas and regions, and many of the members of the profession will be providing support to small regional centres. And I'm alive to what impact the imposition of additional compliance will have on those small accounting practices and the service they provide to their community. So I'm interested in any further information you've got around cost of compliance in jurisdictions like the United Kingdom or New Zealand.
I'm happy to start from a New Zealand perspective, if you like. We've had a lot of feedback from our small and sole practitioners based in New Zealand that the cost of compliance is quite excessive and not really in a risk-reward sort of balance when they're actually looking at the benefit that it's actually giving back to both the system and the integrity and also the consumer. The complexity of the framework that they have to comply with means that they have resorted to outsourcing their CDD obligations because it is such a process to go through, and that can cost anywhere from $50 as an individual through to up to $500 depending on the different structures that are actually there, and such as trusts that Ben had alluded to before. So, you know, we're very mindful that there is an excessive sort of cost that's coming through in that New Zealand framework, and we wouldn't want to see that replicated here, especially because, as to your point, it's going to be passed on to the end consumer because the small business, being the professional accountant, often can't absorb those costs.
So, Ms. Waller, is it possible for you to take on notice that issue, because it's a very, very important issue, and we did receive evidence earlier today that basically was along the lines of that some of the information being provided or submissions being made around cost incurred by professional services firms is overblown. It's exaggerated, and there's a bit of a henny penny approach being undertaken by some of the professional services firm agencies in terms of the cost. So is it possible for you to take on notice and provide additional information with respect to what your members are actually seeing in New Zealand?
Yeah, definitely.
Senator Scarl, can I make one other suggestion? Would it be possible for the Secretariat to provide a Hansard of the evidence that's been provided on these cost issues and ask the witnesses if they'd comment on that in addition to your question, just to get because it's quite a marked discrepancy between the evidence we've seen from some of the submissions and some of the material we've seen today. Would that be acceptable to you, Senator Scott, if we get those two things put together?
I think that's a very good suggestion, Chair, because from my perspective, this is a key point, and there is a discrepancy, as Senator Carr has alluded to. So I think that would be very helpful. And I actually think it's extraordinarily important for each of the professional associations.
Yes. So, but I think it's important also to get an understanding of what's actually being said in regard to new technologies and the areas of activity that are subject to compliance costs. I mean, there could be some argument about what it is we're actually measuring. So if we can actually look at the evidence that's been presented, and then you can make your own judgments, in terms of the validity of the claims that have been made.
May I also add, in terms of costs, it will obviously be dependent on the requirements.
That's what I'm saying.
Yes. So if you look at the UK example, which has a very complex system, I'll give you one example of cost. Software that we have until now, up until next month actually, provided free of charge to our member firms to do some of their CDD work. That is now, it's no longer viable for us to provide that free of charge. So that's now going to be provided at a cost of £260 annually, which is about $475. And that's for the small firms. And the majority are very, very small firms. So that is one cost. And then, of course, there are the levies that they have to pay as well. So all of those things would have to be taken into consideration.
Indeed.
The last question I have is really around the role of the professional services organisations. And from my perspective, I think it's going to be absolutely fundamental as the law is reformed, it rolls out to tranche 2, that the professional associations work hand in glove with the government in terms of coming up with the right policy mix for each of the professions and making sure that the system is as effective and efficient as possible. Because it seems to me the professional associations are going to be at the coalface in terms of rolling it out, assisting their members to get up to speed with the new regulations and introducing it in their practices. I'm just interested in your thoughts with respect to that proposition. Is that a fair comment?
Certainly, I think it is, Senator. I mean, our experience in New Zealand is certainly that what we need to be doing is working very closely, I guess, with government, as not only is the legislation, I guess, designed and then subsequent the subordinate legislation and regulations, but also that implementation part and guidance and so forth. I think it's got to be a very collaborative process to really, as we indicated, probably leverage what is already in existence for our members effectively, and then, as you say, work out where the gaps are for where there is additional bits needed to, I guess, take it up to the level of FATF requirements. And certainly what we did find out through the New Zealand experience is the implementation time is really quite key. It can be quite an uplift for some member firms, and so we need to actually work very closely with them and build that through into their processes so that they are ready when it actually becomes effective. Because often these things do take time following the passing of legislation to actually come up with what this means in practice.
Can I just add to that? Having gone through 12, 13 years of these know your client obligations and assisting issuers, I still have members today ringing asking how they ID certain types of individuals, certain types of companies. Different products have different requirements, and so there is a lot of confusion still 12, 13 years into the regime. the simpler and clearer you can make it up front, the easier obviously it is over time to roll it out. But if you create a highly complex requirement for a particular profession, then it can go on a long time.
Well, can I add to that question? In other areas of industry policy, where there's a change in compliance, it's not unknown for the Commonwealth to provide assistance to industry associations to assist industry firms come to grips with the new regime. Would that type of a program for a limited period be of assistance? Now, it may well be that in some areas of regulation, there'll never be a point at which firms actually come to understand things. I mean, I know in the R&D tax area, I know there are firms that constantly manage to get have a misunderstanding, many years after it was introduced, and they rely on taxation accountants who might end up at the practitioners board because of their misunderstandings of things. That is, the accountants themselves end up at the practitioners board. So with that principle of industry associations being given some temporary assistance to actually assist in a transition for a new regulatory regime, would that be of any value?
I would like to comment first and say I think that would absolutely be welcomed by the profession. What we have seen, especially in our smaller and sole practitioner firms, is that they have undertaken a significant amount of reform and regulatory change in the last 24 months. And what we've especially seen in the last 12 to 24 months is the impact of COVID and trying to support their SME clients through that change. They've had significant capacity issues. They've had to invest in a lot in moving remote working in areas that had lockdown for long periods of time. And that's had a considerable impact on their capacity and their resourcing and obviously their financial means as well to be able to implement more change. So we would definitely welcome that opportunity.
Okay.
Yeah, and can I just add that, assisted compliance, I think, is something that's been used in the UK quite effectively. So, as Ketty said, that would be extremely welcome. And
in the United Kingdom, how did it work? How did that industry support work? Can you explain that?
I think it's worked in different ways, so that they've looked at things like, for example, whether certain sectors need to have exemptions. They've assisted them with their understanding and education and awareness. And they've assisted them with how different parts of the regime apply to different sectors. But I think the problem with the UK, from my understanding, is that it's so overly complex.
Okay, so you've got some philosophical objections to the regime, but I'm interested in how the government in the United Kingdom assists firms to come to grips with the regulatory regime. Now, are you saying that the government provides assistance through industry associations for that adjustment?
Yes, it does. It provides assistance, but also it's a very different kind of regime.
Yes.
Because they've set up OPBAS, as it is, which is a supervisor, and then they've authorised professional associations to be supervisors. So there is assisted compliance, and I don't know if that's exactly what you're getting at.
Look, as a former minister, we provided management consultancy services. This is the Labor government provided management consultancy services through Enterprise Connect, for instance, which would work with industry associations to lift the capability of firms in a whole range of areas. But the biggest problem I find in terms of working with my historic experience is moving from a small enterprise, moving from, say, a trade firm, moving into a larger, understanding their regulatory requirements, even for basic requirements such as payroll. Now, you're dealing with this on a daily basis. You're actually providing a service to firms to meet their regulatory obligations. That's what taxation and various other financial services provide on a daily basis. Now, if the Commonwealth's asking for an additional level of compliance, well, then maybe there's a case for there to be further assistance so that people understand what's required and takes away the argument, it's too hard, it's too difficult, it's too costly. We're being told there are a range of ways of dealing with that to minimise costs so that we understand the nature of the ask. It's not the same as the Commonwealth Bank, but it is certainly a requirement to register, particularly when the beneficial ownership test and such matters are critical to our capacity to defend the country against corruption. Then maybe we have to provide some assistance to small enterprises, and in your case, financial service companies, to be able to provide that. That's the argument I'd put to you. We have done it in the past, I know in my direct experience. Is there a case for it to happen in the financial services area as well?
Yes, I think definitely there is a case for it.
Right. So, Senator Scarro, I've intruded on your questions. Have you finished with that?
No, I was happy with your intrusion. You're a welcome visitor, so I'm happy to pass back to you, Chair.
All right, no worries. Well, if you're done, because as you know, I'm looking at the clock. Always looking at the clock. So, Senator,
I'm done.
Are you done? Thank you, Senator. Is there anyone else? Any of our other colleagues have questions? If I could ask our secretary to make inquiries, and Senator O'Neill, if you're keeping an eye on the clock as well, I'll turn it to you. Okay?
Thank you very much. I just want to be clear about your submission to us today that I did hear you say we welcome moves to strengthen AML CTF. You're aware that Tranche 2 is a long time coming. Is there now some acceptance amongst the accounting profession and Financial Planning Association that it is inevitable now that Tranche 2 must proceed?
Yes, Senator, I think certainly from the IPA's perspective, it's something that, we've been involved in consultations from the days of the Attorney General's Department for many years, really. So I think there has been an expectation that Tranche 2 will be introduced. So I think that it's just a case of, if I could say, when rather than if.
Much promised, but undelivered. I wasn't involved in the 2015 MER, and neither was I involved with the 2016 significant review. And I don't know if you've had a chance to look at submission 32, which is from the Border Force, I think. Yeah, Department of Home Affairs submission to this inquiry. They've gone at the end of their submission to track what happened with the 84 recommendations that no doubt you were a part of the consultation back in 2016, which was when the government was promising to do this. A lot of water's gone under the bridge between 2016 and now, including the Royal Commission and changes that you've been talking about here in terms of regulatory change. But this is a massive body of work that remains unattacked. So are you concerned about the wastefulness of, having gone through this process in 2016 only to have to really recommence it here in 2021?
I suppose from our perspective, we thought that sooner or later it would happen. There's so much regulatory reform that goes on constantly. It's relentless, really. So I suppose, and I was involved back in 2015 and 2016, and I remember presenting before the Financial Action Task Force and being, almost interrogated, as it were. So I do have memories of all of that. But I suppose it's just a case of, here we are. It'll happen when it happens. It's not something that's within our control, but it's, there is so much other regulatory reform that happens, and I suppose we just wish to ensure that all the regulatory reform that has happened since 2015 and 2016 is taken into consideration.
Yeah, because it's a bit of a dog's breakfast, as you describe it. There's a little bit here and a little bit there and a little bit over here. And there's no clarity, I think, for the sector about exactly what now might have to happen. So I guess my first serious question to you is, has the government discussed with you, any of you and your organisations, their plans as of today to implement Tranche 2 that will cover your profession?
I can't speak for the others. They can speak, but not with the IPA.
So it's still somewhere on the horizon, but not a focus for government, and certainly not a conversation that's live for you, and you are representing, if I can go back here, the Institute of Public Accountants.
Yes, correct.
Okay. So could I ask Miss
Styliano.
Miss Waller for
Waller.
CPA?
No, we have not had any direct conversations.
So this is not a item of work for the government, and you are not in conversation with them about that, tranche 2?
We've not had a direct conversation on tranche 2
Thank
recently.
you. Ms McWilliams for CANS?
Likewise, we have had no direct conversations with government around the current status of this.
Of the tranche 2 reforms
Yep.
to AML CTF, yep. And Mr Mention? Is it Martian?
Martian.
Sorry.
Martian. Sorry. No, that's all right. So as I noted in our introduction, financial planners are already item 54 reporting entities. So we're already under the AML CTF Act, and part of the regime. Tranche 2 is not something that we've had a discussion with government about because we are already within.
Yeah, so you're within Part B of tranche 1 based on your evidence, but you have not, I want to be clear about this, that you will still be impacted by tranche 2, but you are not in any conversation with the government currently around tranche 2.
No, that's correct.
Does it surprise you then that recently in Rome, at the G20, Australia signed off with the leaders' declaration on AML, CFT and CPF, reaffirming our full support for the Financial Action Task Force and the global network, stressing the relevance of risk-based approach of the FATF recommendations with the aim to ensure legitimate cross-border payments and promote financial inclusion, among many other things. Does it surprise you, Ms Styliano, that the government continues to herald its action on FATF regulations overseas, yet they are not engaged with you at all on tranche 2?
I can't say that I'm aware of what activities or discussions the government has had with others. I can only comment and say that they haven't had any with us.
Mr Martian, are you aware of this international stance, looking like we're a good international citizen but not doing any of the work at home?
I'll be honest, I'm a little bit more focused on my kindergarten child's reading ability than following what's happening in the news in Rome. So no, I haven't followed that, sorry.
Okay, but it does matter how Australia is represented. We are part of an international economy, and money is moving across borders all of the time, and your clients, your members would be critical in the ethical movement of that money. So it does matter what we present to the world as our public face, doesn't it?
Yes, I suppose it does, but it's just not something that I can really comment on.
Thank you. Ms McWilliams, do you have a comment?
No, I think as we've indicated, I mean, Australia has committed to implement the Financial Action Task Force reforms, but I guess it's a matter for government as to when those are implemented in terms of timing. And
based on evidence we received this morning and confirmed in submissions, are you aware that Australia is one of the being described as a laggard in implementation of tranche 2?
I am aware of what's been written in some of the submissions and what's been written in the media, and I have looked at the FATFA website.
So, in your view, Ms Styliano, is there any other significant legislation that you consulted with this government on as far back as 2015 and 2016 that remains completely unaddressed? Or is this it?
I think that there might be examples along the way, but nothing that is relevant to this.
So this is a pretty big oversight by the government not to implement this, despite its rhetoric to the effect that they were actually doing it.
I think it's really just up to government. Mm-hmm. It's not something I can comment on.
In the 4 years since the government promised a cost-benefit analysis of regulatory options for designated non-financial businesses, has there been, to your knowledge, any effort whatsoever to start that cost-benefit analysis process, which is so important to you that you've given evidence about it this afternoon?
Not that I'm aware of. It is something certainly that we would definitely emphasise, and I know that back in 2015-16 the Attorney General's Department did recommend that, and is something that we would definitely seek to happen.
But there is no idea currently, there has been no work done about the financial implications of Tranche 2 on your members, is that correct?
Not that I'm aware of, apart from what we've been doing ourselves.
I'm surprised you didn't actually have that information from the government years ago, but I am particularly concerned that as we sit here with international declarations about supporting the FATF reforms and Tranche 2, that the government has not interacted with you to get a cost-benefit analysis underway at all. It would be useful for your members, I'm sure, and I'm sure they'd be interested in knowing what that might be. You've spoken about New Zealand, you've also spoken about the UK. In terms of those jurisdictions and any others, are you aware of the effects of the implementation of Tranche 2-like reforms in other jurisdictions and their impact on viability of businesses? I mean, I know that there's a cost in change. What has happened in terms of other jurisdictions? Has there been a collapse of the industry, or has there been significant failure of small or medium businesses as Tranche 2 is implemented in other jurisdictions?
I don't have any particular knowledge of that, only what I've read in other submissions, but I don't have any particular knowledge of other jurisdictions.
Okay. Mr Manchin, have you got any response to that? Do you know anything about other jurisdictions and, you know, the loss of financial planners?
I know plenty around other jurisdictions and the loss of financial planners, but not in direct relation to money laundering and terrorism financing laws.
Okay. Ms Waller?
I'm not aware of an impact on the viability of any of the businesses for professional accountants. I know it's had a cost impact, but not around this, the continued financial viability.
Okay, and Ms McWilliams?
What our experience has been with New Zealand, and it's important, I guess, to note that the New Zealand regime is activity-based, so it's based on whether or not you undertake a captured activity as an accountant, as opposed to just whether you're an accountant. We do know that, I guess, some of those smaller firms who might have only undertaken 1 or 2 captured activities a year have, I guess, moved away from doing that work, so that they are not part of the regime, as opposed to those who perhaps do a significant amount, who are therefore fully within it. So I wouldn't have said it's affected their viability, but we have seen, I guess, some firms probably cease some of the services that they provided in order to, I guess, be able to continue to service their clients at that lower cost,
So,
where they are in that smaller end.
so in some ways it could become a specialised field with some people carving themselves out of it.
With it being activity-based, it is based on those higher risk activities. So effectively, members are choosing not to do higher risk activities that are captured by the regime, and seeking to, I guess, focus their efforts on lower risk clients, and therefore able to just sort of stay servicing them as they would have done normally. But it would have been those that are sort of only had a few, I guess, clients that might have been in the higher risk, or a few pieces of work for them that were considered higher risk and captured. It was very much on that border.
Could I ask if you have any significant interactions with AUSTRAC currently?
We've had IPA that has had interactions, not recently, but certainly over the years in terms of training, education, awareness, that type of thing.
But you wouldn't call it an ongoing and intimate relationship with AUSTRAC? You don't report significantly to them?
No.
Right. Ms Waller?
No, similar.
Mr Martian?
Yes, so the Financial Planning Association has not scheduled but somewhat regular meetings with AUSTRAC on a variety of issues on a regular basis, and 2 to 3 years ago, AUSTRAC worked with the Financial Planning Association on doing a post-implementation review and to get an understanding of how financial planners were engaging with AUSTRAC, engaging with the ID verification obligations around the risks in terms of the services they provided in terms of anti-money laundering, counter-terrorism financing activities. So yes, we have dialogue with them. I can ask them questions when I need to without any problem.
But you'd say your last formal consultation with them about it was, what did you say, 2 to 3 years ago?
No, that was a specific consultation. Whenever AUSTRAC update rules and make changes to their rule books, we are involved in those consultations, and we'll have conversations with them about those changes as they relate to financial planners.
Right, and that's because you're captured in Tranche 1, Part B.
Correct.
Great. Ms McWilliams?
We don't have regular engagement with AUSTRAC. I think to Vicky's point, we've had some ad hoc engagement with them over the time with various bits of guidance, but it's been very limited.
Once Tranche 2 is implemented, you will have an incredible asset to share with AUSTRAC in terms of reports of anything that you see that you think is suspicious or unclear. And as was revealed today, I think in evidence from the police representatives, they would have comparative sightings across the industry. You know, like if you're a big tier 1 company, you might have 5% of your transactions that you would say this needed a little bit of an investigation, report it, and then AUSTRAC would get onto it. What change do you believe and what benefits to the Australian system and international finance will be unleashed when Tranche 2 is implemented and your respective professions are engaged?
What benefits? Well, I suppose the idea is, in terms of the objective and the objectives of the legislation, that the wider the net is cast, so to speak, that more activities, suspicious activities, potentially illegal activities might be caught in that net, which would benefit the economy more broadly. And I suppose I'm going by the policy objectives in the legislation, which, you know, we've always supported. So I suppose to us that's certainly one of the main benefits.
Is there anybody who wants to add anything to that?
Yeah, I'll make an additional comment if I can, please.
Thank you, Ms.
And just
Waller.
say, I think if we have an ability to collaborate and look at how Tranche 2 is implemented, so we have some cohesion across obligations, be it through ATO, the Tax Practitioners Board, Corporations Act, AUSTRAC, so we can have a level of consistency. I think that'll bring a level of integrity to the system. I think the other thing is a potential level of efficiency. So at the moment, as Ben alluded to in his opening comments, there can actually be different points of having to go through some of those CDD obligations because it's not always accepted by all parties. If we can actually bring that together and have a consistency in recognition and one point of verification that could be shared, that could give a lot of efficiencies and integrity to the system.
Absolutely. You actually, this
Sorry,
next...
I-
Yes, Mr. Martian.
I was just going to note, we obviously have been involved in reporting suspicious transactions to AUSTRAC over the years. The reality is, and AUSTRAC confirmed in their review, there's virtually none that come through financial planning because the relationship between the financial planner and their client is of a type that financial planners are generally across enough information and the financial position of the client to be on top of those kind of risks. And financial planners often won't engage with clients when they see risky types of behaviour, but will also report those through because of their professional obligations that they have. So there's been virtually no suspicious matter reporting that's come through financial planners as a profession because of the relationship that planners have with their clients. And when they tend to have been where the tests for suspicious matter reporting have been set in such a way that, for example, somebody doing renovations or building their house are taking regular payments or regular amounts of money or transferring regular amounts to different builders and contractors and things like that, that tends to have triggered the reporting programs rather than there actually being anything suspicious to report.
Nonetheless, I expect with the profession, the breadth of the profession that you're representing there, once you've got the skill set and you know how the system works, there is the old expression, a gun for hire, and we've actually heard today about professional service providers, and I do put that in inverted commas, that are advertising their services to overseas entities about how to get around Australian law. So, I mean, there are unethical operators in every industry, and I'm sure that there would be some who, after a period of time of skilling up, could become literally a very valuable asset to somebody who wanted to launder money within the country or from overseas. So I guess there's a reason for capturing that, isn't there? You raised the issue of overlaps and duplications, and we had some evidence live today about that with the Tranche 2 requirements and current professional standards. Could I ask you just to take on notice anything that you think in addition that you want to alert the committee to? Where are the aspects of Tranche 2, to the very best of your knowledge, already covered in Australian law? If there's anything further that you need to add to what you've already put on the record, I'd appreciate having that. Senator Carr asked a little bit about collaboration and the costs of doing so and the benefits of doing so. The UK implementation was focused on collaboration with industry bodies such as yours. How can the government best work with you to ensure that these reforms are implemented in a way that doesn't result in onerous regulation on your profession, while still getting the job done and restoring Australia to the good books in terms of international corporate participant in the world economy?
I
think one of the benefits... Oh, sorry, Vicky.
No, you go, Kitty.
I was just going to say, I think one of the benefits of working with the professions like ours is that we have the ability to engage directly with our members who will be implementing this at the coalface. And quite often what we see is policy intention or legislative obligations that we're looking to actually achieve an outcome. But when it gets to that implementation or how it actually goes to unfold, we don't always hit the mark. So I think that if you actually engage with the profession and we actually use that as a conduit through to the members who will be actually implementing this at the coalface, understanding existing systems, the processes and how that can actually come into a day-to-day setting, you'll actually get the best outcome because you'll be able to leverage what's already there, understand how it's going to unfold and ensure it's going to actually hit that policy intent.
Which makes it even more inexplicable why you are not being consulted by the government at all, given your knowledge. Did you want to add something, Ms. Stiliano?
No, I was just basically going to agree with what Ketty said. It was I was going to make similar points that, you know, it's the sort of stuff we've already been talking about, and I think to your point, Senator, previously where you talked about where is Tranche 2 already covered in the existing requirements, I think that sort of mapping and stock take will be very, very critical as we move forward.
If I could ask you, Ms Waller, you indicate in your submission very clearly you're supportive of applying Tranche 2 to the gatekeeper businesses. What kind of regulatory framework do you think would be most effective to implement? And also, what kind of whistleblower protections do you want for your members?
In terms of the regulatory oversight of what we'd like to see, I think it's about working with that existing framework. So we've already spoke about the fact that there are obligations under the tax profession and under the TPV obligations. We also have obligations under our professional code of conduct without no-clear or non-compliance. So I think it's about if we can actually look at how we can bring those obligations together so we're streamlining those. That'll have the best impact. In terms of whistle protection, I think the same sort of protections that we would expect, and we already have in some of these places, is ensuring that they've got legislative protection. I think one of the challenges you see is when you're dealing with a small business and if you have someone who comes in who may have a suspicious activity, that they would be quite readily identifiable if they actually then report that individual. So we need to ensure that we put protections in place that we're going to protect these small practitioners and small professionals so that they're not going to be a target if they actually are doing the right thing and reporting this non-compliance.
Okay, that's a very good point. Did you want to add anything, Ms Stiliano?
No, that's fine, thank you.
Thank you. Could I ask all of you to see if you have a view about this? Ms Stiliano, you talked about the structure in the UK setting, and I understand with the law societies in that country, there's 3 different jurisdictions and they've got slightly different models, etc. We've got jurisdictional challenges that have become very, very obvious to us during COVID. I'm kind of interested in your view about what would be the best way to proceed. You know, is AUSTRAC the appropriate place with the sufficient expertise? Does it have adequate resources? Does it have the right people to implement and monitor Tranche 2 successfully in terms of capturing your profession? If so, yes, why? And if not, why not?
My understanding is that AUSTRAC would need additional resources if Tranche 2 was to come into play, given that, you know, there would be up to, you know, potentially 100,000, you know, different entities that would need to report one way or the other. So as with other regulators, it's, you know, we're constantly saying to government, please ensure that they're adequately resourced to do what they need to do. You know, for example, with ASIC and the ASIC industry funding levy, you've seen what's happened there.
Especially with financial planners.
Yes, especially with financial planners. And we're also advocating for the similar relief for liquidators and auditors, I might say. However, we don't want to be in a similar situation where it's, you know, the profession and industry that's bearing the cost through increasing levies. And I know that in the UK there's a levy paid to OPBAS, for example. So we don't want to be in a situation where, you know, there's another cost to industry and to the profession because AUSTRAC or whichever agency it might be is not adequately funded and resourced. I mean, at the moment it looks like AUSTRAC is at the moment, and I stress that, the most likely candidate to take this on, but that's really something else that I should imagine will be subject to consultation.
You would hope so.
I would hope so, yes, exactly, Senator.
But it is a few years in between, shall we say, in terms of consultation. 2016 to 2021, it's definitely not a love affair, is it?
Well, I think there's a lot to be consulted on in terms of Tranche 2, and if we were to start today, I don't know how long it would take, but I would certainly hope that sufficient time would be given to careful consideration, including a cost-benefit analysis and all the other things we've talked about.
Does anyone else want to add anything to that? Is AUSTRAC the best place to be managed?
I think not just, I suppose, talking about whether or not it's AUSTRAC the best place, Senator, and I wouldn't want to I'd probably echo Vicky's thoughts on that. But I think if, to Vicky's comments around, you know, ensuring it has sufficient resources, I think that also comes to that earlier comment about actually working in collaboration with the industry associations, such as ourselves, to actually ensure that, I guess, we provide the necessary knowledge and an understanding of the sector to those people within AUSTRAC who will be, if it is AUSTRAC, who will be regulating and supervising the sector. Certainly our experience in New Zealand is that it took a bit of time, I guess, for the supervisor in New Zealand to get actually up to speed on the various differences across the Tranche 2, I guess, professions. They're not all the same, and in fact, they're actually very, very different. And so that does require quite different knowledge and understanding. And I think it's certainly my point would be for whoever is going to be doing that to work very closely with the relevant industry associations across the Tranche 2 professions to ensure that actually there is that understanding of how it will work.
Can I ask one final question? How confident are you that the professionals who have incredible licence because they are considered a profession, and there's an ethical stance that's embedded in the whole concept of a profession because there's so much power. How confident are you that yours is a clean industry, that you haven't got people in there who are making their wealth out of facilitating exactly the kind of behaviour that Tranche 2, which should have been implemented a long time ago in my view, is designed to prevent?
I think that no matter how much you legislate or regulate it would be virtually impossible to ensure that there are no bad actors and no bad players in any profession or in any industry. All we can hope to do is minimise it, and I think certainly when you look at the professional accountants, being the members of the 3 professional accounting bodies, we have robust systems in place that have been in place for, approximately 100 years. So, there's a certain level of confidence. The accountants are called the trusted advisors after all, according to a lot of research and surveys, and that's something that they take very seriously. And our job and role as professional associations is to make sure that we do everything so that they maintain that trusted advisor status. However, I would make a distinction between members of the professional accounting bodies and those who are not members of the professional accounting bodies. So, because accountant is not protected at law, so there might be some out there who call themselves accountants. We have no regulatory oversight of those people, so I would make that distinction.
It's a little bit like cosmetic surgeons in another inquiry we had the other day. They're actually not surgeons, and they're operating in that way. Can I, though, remind you of the recent media reports about the practices in auditing companies, where there's been gross breaches of professional standards, with tests being, taken with people having the answers already prior to going into them. So do you remain, in the context of that reality, confident that the standards of ethical behaviour are really robust, or are they being eroded by, practices of making money over practices of doing the right thing?
I think the point to emphasise is that there are consequences, so that if people do breach the rules and the regulations, that there will be consequences for doing that. And I think that's what sets the profession aside from the others, if I may put it that way.
I guess the consequences in that sector only came because of a US regulator, not an Australian regulator. Perhaps there's some warning there.
Yes, and I suppose there's something to be said for the fact that they were self-reporting, but I'm not going to get into that.
Thank you
We
very
should
much.
get into
Appreciate it.
Thank you.
And I would thank you all very much for your attendance today and the advice that you've provided to us.